Now,
And
I think you must be host because now this thing keeps coming up to admit people. Can you
yeah,
also?
yeah, we'll be admitting them. Don't worry, that'll come on your screen because you're the co-host as well.
Okay.
But you can ignore that. That we'll take care of that.
Okay. Not a problem.
Yeah. All right. So we'll start today's session. Good evening, everyone. Thank you for joining in for the series of webinars on the new labor codes. Before we begin, I'd like to introduce the organizations that are hosting this session and our speaker for today. We shall start with NSS. The National Service Scheme is a government-sponsored public service program conducted by the Ministry of Youth Affairs and Sports. Popularly known as NSS, the scheme was introduced in 1969 with the primary objective of developing the personality and character of the student youth through voluntary community service. Very appropriately, the motto of NSS is "Not me, but you." NSS attempts to establish meaningful links between campus and community, college and village, and knowledge and action. The NSS unit of Government Law College, Mumbai was formed 11 years ago. Our primary means of providing service this year has been through imparting educational online sessions. This webinar on the new labor codes in collaboration with HRLN is our latest effort towards that goal.
Neil, you are on mute.
Yeah, sorry for that. The Human Rights Law Network is an organization with an aim to create a justice delivery system that is accessible, efficient, accountable, affordable, and pro-poor. HRLN views the legal system as a crucial instrument for realizing human rights, but they recognize its limitations. Seeing the struggle of the marginalized, they participate in the struggle too through various activities including public interest litigation, advocacy, legal awareness programs, investigations into violations, and publishing Know Your Rights materials. Speaking on behalf of HRLN today on the topic of the Industry Relations Code, the final code to be discussed today, we have with us Advocate Gunjan Singh. Advocate Gunjan Singh is a lawyer based in New Delhi who specializes in labor and employment laws. He is a recipient of the Shrivaning Scholarship 2017-18. He holds a degree in law from Aligarh Muslim University, India, and Masters in Social Work from the Tata Institute of Social Sciences, Mumbai, India. He additionally holds an LLM in Human Rights, Conflict and Justice from the School of Oriental and African Studies, University of London. He's currently working as a director with respect to litigation at the Human Rights Law Network, Delhi. He started his career in litigation working with trade unions in Gurgaon in India. And for a brief period, he also worked as a researcher on an ILO commission study named Evolution of Industrial Relations in Gurgaon and Worker Responses, where he mapped the gaps in grievance redressal mechanism under the Indian labor laws. His interest lies in strategic litigation on human rights issues and thus has been actively involved with several civil society organizations in India and abroad. He was recently invited as a speaker on a panel titled Strategic Litigation Impacts Global Case Studies at the International Bar Association Annual Conference 2019 at Seoul, South Korea. He was also invited to speak at the Earth Trusteeship Forum 2019, Bangkok, in Thailand. So we are incredibly happy to have you with us today. And before we begin, I would like to remind the NSS volunteers here that for the purpose of your attendance, you have to comment your name and college name as early as possible in the YouTube live chat, that is before 4:15. Take a screenshot of it and upload that screenshot in the feedback form, which will be made available at the end of the session in the YouTube description and your WhatsApp groups. All right. And with that, sir, you may begin your session.
Thank you, Neil, for the long introduction. Dear all, thank you for organizing this webinar on new labor codes and, of course, inviting me. The new labor codes remains one of the most contested yet ignored aspect of today's politics. There's barely any on-ground agitation against these codes, like the ongoing farmers' protest movement in India. In fact, the impact of the labor law changes is larger than the amendment in the farm laws. As the rough estimates suggest, there are about 450 million workers in India. And with these codes being brought in, these workers are going to be impacted. Sporadic protests here and there and resistance against the new labor codes by the Central Trade Union is depressing and worrisome. The new labor codes, there are 4 codes: Industrial Relations Code, Wage Code, Social Security Code, and Occupational Safety and Health Code, aim to consolidate almost 44 central labor laws. The Second Commission on Labor Conference 2002 recommended consolidation of labor laws into broader groups. There has been also long-standing demand from the employers group of simplification of the labor statutes. It was often complained that the present set of labor statutes make the compliance system complicated and the labor inspection system is corrupt. The present government, citing these reasons, brought the new codes. Today, I'm here to speak on Industrial Relations Code. The Industrial Relations Code, one of the four codes, replaces three existing statutes, namely Industrial Disputes Act 1947, which provides for the dispute resolution mechanism in cases of industrial disputes. I'll explain in detail about this particular act because this remains the cornerstone of the labor laws in India. The other act is Trade Union Act 1926, which deals with registration of trade unions in India. And third, Industrial Employment Standing Orders Act, which deals with model standing orders in industries having more than 100 employees. Rationalizing the amalgamation of three statutes, the above named statutes, the Standing Committee report on Industrial Relations Code states as under. This will be important because what is the reason being given in order to put together these codes and to replace them with replace the existing statutes with the new codes. And this is the reason given by the Standing Committee report. And I quote, the Industrial Relations Code 2019 intends to subsume the above three industrial acts after simplifying and rationalizing the relevant provisions contained therein. The codification of the above labor laws by consolidation of relevant provisions at one place aims at facilitating the implementation and removing the multiplicity of definitions and authorities without compromising the available safeguard. The code proposes to bring transparency and accountability in the enforcement of labor laws, which would lead to a better industrial relations and thus higher productivity. The ease of compliance of labor laws would promote setting up of more enterprises, thus catalyzing the creation of ample employment opportunities in the country. So this is the background. This is the reason given by the government to bring in this code. Now, before going into the nitty-gritties of the Industrial Relations Code and the changes brought in by it, it is important to understand the pre-code mechanism. Out of the three statutes mentioned above, the Industrial Disputes Act remains the most important. The Industrial Dispute Act 1947, which is a pre-independence legislation, is considered to be the cornerstone of the Indian labor laws. During period independence, it was believed that to boost Indian economy, industrial peace is necessary and a separate exclusive system to be put in place. Now, many of you will note that post World War II and the early years of independence, all the new countries which got independence, there was a lot of thrust on making economic progress and social justice. So this act has to be understood in that background. This act provided for dispute redressal mechanism for industrial disputes between employees and employers, employees and employees, and employers and employers. It is often, this aspect is ignored, that Industrial Disputes Act is considered as an act which only resolves dispute between employees and employers, which is in fact is not true. If you read that, it provides that it also provides grievance redressal mechanism for any dispute, even between employers and employers and employees and employees. So this is a very important aspect of this statute. Now, in the backdrop of the recent Industrial Relations Code, it would be very important to highlight one aspect of Industrial Disputes Act and what it provides. And it is that it discourages hire and fire policy. Now, what do we mean by hire and fire policy? Hire and fire policy means that an employer can hire an employee at any point of time, and they can fire that employee at any point of time. It is totally at the whims and fancies of the employer. ID Act discourages hire and fire policy employed by the employers and protects the services of the workmen who have been completed 240 days of continuous service in any establishment. Now, many of you who are not aware about the labor law practice, and this is one of the technical aspect of this act, that what is 240 days and what is continuous service. So if you practice labor law, you realize that all the rights under Industrial Disputes Act are only for those who are workmen. Now, who is a workman? Workman is one who completes 240 days of continuous service in any preceding year in any establishment. So if you have worked for 200 days in any company, you will not be qualified as a workman, and the rights under Industrial Disputes Act will not be applicable to you. So this is the importance of 240 days. Now, no employer can terminate the services of any workman as defined under Section 2S of the Industrial Dispute Act without following the process as laid under Chapter 5 of the Act. Now, what is Chapter 5? Chapter 5 has provisions for compensation in cases of layoff, retrenchment, and closure, and lays down the process of laying off, retrenchment, and closure. Now, again, these are the concepts like laying off, retrenchment, and closure, which are important for labor law practitioners and trade union members. Laying off is a temporary termination of service by any employer and can be for many reasons. Suppose lack of raw materials, some other factor. Retrenchment is a permanent termination, and closure is when any establishment is closed down. So these are the different ways where the services of a workman comes to an end. Now, how does Industrial Disputes Act prevents hire and fire policy? That it lays down the processes that you cannot terminate an employee on your whims and fancies. You have to follow certain steps which are laid down in Chapter 5, which provides for that you will pay compensation. In other cases, you'll have to serve them a notice, conduct domestic inquiry, follow a process. Then you can terminate a person. Now, one of the most important and a contribution in the field of labor laws in India of Industrial Disputes Act is the twin concept of reinstatement and back wages. Now, this is the most important aspect, and I'll delve in this in detail. The concept of reinstatement and back wages are the most vital aspect of this act. Both these concepts are not mentioned in the act, but are the result of judge-led jurisprudence. Now, before I go into that, what do we mean by reinstatement? Reinstatement is a unique concept and an anathema to the principle of specific performance of contract. Now, what is a specific performance of contract? That if a party fails to perform the terms of the contract, the courts cannot direct a party to implement the terms of contract, but can only provide damages. But under ID Act, the popularly known Industrial Disputes Act is popularly known as ID Act, industrial tribunals have power to direct employers to reinstate a workman if the termination of the employee is held to be illegal. Now, reinstatement means when you put that person back to the same position which he was before his illegal termination. In the iconic Western Indian Automobile Association case, the Federal Court, which is the predecessor of the Supreme Court of India today, held that the industrial tribunals have power to grant relief in the nature of reinstatement while adjudicating industrial disputes. Now, if you read Industrial Disputes Act carefully, you'll not find mention of word reinstatement. So it was because of this that in this case it was argued that there's no concept of reinstatement. Industrial tribunals cannot direct employers to reinstate their workmen once the services comes to an end. Now, the maximum they can do is to provide some sort of damages. Now, in this particular case, judges dealt in detail the terminologies used in the Industrial Disputes Act and held that no, it is well within the jurisdiction of industrial tribunal. They have discretion that once they hold that the termination of any employee is wrong, is illegal, then that employee has to be given duty back, what is called reinstatement. Similarly, the concept of back wages also developed, as reinstatement meant that the services of the employees was wrongly terminated and they shall be deemed to be in continuous employment. And if the services were never terminated, as if the services were never terminated. So once it is held that termination was illegal and the employee has to be reinstated back to the services as if services were never terminated, therefore they shall be entitled for the wages of the period they were out of service because of illegal termination. So suppose a worker was terminated in the month of March 2020, where actually thousands of workers were terminated, their jobs were terminated because of pandemic. And an year later or a 2 year later, an industrial tribunal holds that the services of the employees was wrongly terminated. So once it is decided that the services of the employees was wrongly terminated, it means that it is the fault of the employer. And once it is a fault of the employer that they illegally terminated the employee, they'll have to give that worker their job back. But what happens to the period for which he was not in the job? For the period which he was not on job, it was the fault of the employer. So for this period, the concept of back wages comes to play. That for this period, since it was your fault, so you must pay back wages to the employee. Now, this is also a very contested concept. You'll see in 1970s, 80s, when we still were in the era of socialist republic, that judiciary encouraged this concept, and in all the cases where termination was held illegal, reinstatement with full back wages was the normal rule. So suppose a worker, as I gave this example, was terminated in March 2020 and he was reinstated back in job in January 2020, then for this whole 9-10 month, he has to get his full salary as if he was never terminated. This was the normal rule that if the termination is illegal, full back wages has to be paid. In Hindustan Tin Workers case, Supreme Court dealt specifically with this aspect and held that where termination is illegal, normal rule is to pay full back wages. And in this case, it was argued, that since companies in the loss, full back wages cannot be paid, some sort of a, loss must be borne by workers, and maybe 50%, 60%, whatever. But Supreme Court did not agree to this. Supreme Court held that in cases where any loss is being cited by any company, why only one party, and that is workers who are already poor, who are already in the power relations standing on the last ladder, should bear the brunt? Have top leadership, have top management contributed their salary? The answer was no. And considering this aspect, Supreme Court held that no, in every case of illegal termination, where court comes to a conclusion that termination was illegal, full back wages has to be paid to the worker. Now, any departure from this rule must be on a sound reasoning, that a reason must be given by court that why full back wages is not being given. Unfortunately, this principle was not strictly adhered by the Supreme Court, and the jurisprudence of compensation in lieu of illegal termination developed in late 90s. And then you will see a series of judgment where court would, held that yes, termination is illegal, but full back wages cannot be paid. And you will have cases and cases. Even today, you will see that in cases 5 years of litigation, a worker will file a case in industrial tribunal, and after 3 years, 4 years, tribunal will come to a conclusion that yes, termination is illegal, and back wages has to be paid, full back wages has to be paid. Then that order will be challenged by the management company to the High Court. Then the litigation will continue, sometimes even for 10 years. Even High Court will, find that yes, full back wages has to be paid. Then again, it will go to the Supreme Court. Again, 10 years, 5 years will be, consumed in litigation. And at the end of the day, what Supreme Court did, that no, full back wages cannot be paid. 30%, 40%, sometimes 10,000, 20,000, this sort of a back wages are paid to the workers. And specifically noting this aspect in Hindustan Tin Workers case, Justice Desai wrote the judgment and he held that it would be some sort of a premium to the employer that, just by protracted litigation, what you're doing actually is that you are weakening workers' struggle. You are, taking undue advantage of your economic status that you can litigate because you're a company, you have money, you can engage lawyers and you can drag on these cases for years. And at the end of the day, if this is the compromise which employees have to make, that out of illegal termination and full back wages, they would pay 30%, 40%, then they would really enjoy doing it. So in order to discourage this practice, in Hindustan Tin Workers case, Justice Desai said that no, full back wages is the normal rule. Now, we see there is some sort of a ray of hope because more recently, I think in 2013 or 10, in the Bali Gundu case, Supreme Court again reiterated that the principle that reinstatement with full back wages is the normal rule in cases of illegal termination. So we see that in a recent judgment also this principle has been adhered to. But by and large, you will see that mostly courts do not give full back wages to the employees. There's an exception to this rule that in what cases you can give full back wages is that if after termination, any worker is gainfully employed elsewhere or employed, then the court has to strike a balance that if for 1 year, suppose he was a bus conductor earning a salary of 20,000 and after his termination, he was, riding an auto and he was earning 5,000 a month, then could strike a balance that since he was making some money, so we'll not pay full back wages, but we'll pay some lesser wage. So this is the two concept. And other than this, there are other concepts under under Industrial Disputes Act, which are important from a worker's perspective, which are going to be changed in the new code. You have the normal process of industrial dispute is that if a worker suppose is terminated, he has to file a claim before labor office, before conciliation officer. Now conciliation is the first stage in grievance redressal mechanism under Industrial Disputes Act. You file a complaint against the termination before a labor commissioner. Labor commissioner conducts conciliation proceedings. Now there can be two things. That in conciliation proceeding, either management agrees that, okay, fine, I'll take you back on duty. Or they say that, no, we will not take you back. You can proceed with the litigation. Now, in cases where after conciliation fails, that is, when employers don't agree to keep workers back on duty, in that case, worker has to approach industrial tribunal. Now, there are time period fixed for it. That after conciliation, which will last for 60 days, the conciliation fails, then after that, there has to be a recommendation by the government that this case has to go before the litigation part starts, where again I have to file my statement of claim. And then I have to again file a statement of claim. Then the company will file their reply. Then both the parties will lead evidence. And then finally, after all that, industrial tribunal will pass the award. Award is some sort of, is the judgment, the final judgment. Now, this is a mechanism by which any employee, any worker approaches labor tribunals. And this is the method which has been prescribed under Industrial Disputes Act for any industrial disputes. Now, other than that, there are, as I explained earlier, that you have provisions that in cases where companies are being closed or where employees are being retrenched, that there's some sort of a safeguard. So these are some sort of a major, aspects of Industrial Disputes Act. Now, what are the changes why there is so much of hue and cry that what is that thing which is being changed in the industrial relations code that the labor rights activists, the trade union activists are fighting against. Now I'll highlight few of the important things which are there in the industrial relations code, which are very problematic and which has potential to break trade union movement and which will be against the interests of the workers. The first and foremost is a fixed term contract. And you'll remember, as I said while discussing Industrial Disputes Act, that the concept of hire and fire, that this act discourages the policy of hire and fire. Now keep that in your mind. And let's take this example of fixed term contract. Now what is fixed term contract? Industrial Relations Code under section 2O, the new code, defines fixed term employment. In catena of judgments, Honorable Supreme Court had held that the ad hoc employment must be discouraged. Right from, in hospitals, you will see many judgments, even more recently, Justice Call, I don't remember the judgment, but he held that, that ad hoc employment should be discouraged for many reasons. And one of them is that employees can never perform to their maximum ability if their employment is ad hoc. Now, what is fixed term employment? Now, fixed term employment means any employer can hire a worker for a fixed term, as the name itself suggests. And they shall be paid the same wages and all that, So on the face of it, maybe one can say that what is wrong with that? An employer is engaging for 5 months, 6 months, and he's getting the same salary, he'll get the same benefits. What is wrong with that? But there is a problem. And what is a problem? That with the concepts like fixed term employment, again, the policy of hire and fire is getting legitimacy. At this time, legitimacy from the parliament, because now the code has been passed. It has an approval stamp of the parliament that any employer can hire and fire whenever they want to. Obviously, this will, once this code is implemented, this will promote hire and fire policy where employers shall employ workers for a limited period and will replace them with a new set of workers. When you'll often see when they're unionizing when they see that they're unionizing, when there is some sort of any demand from the workers' side, which would not be taken in good spirit by the employer, the normal consequence will be they'll be terminated. And the threat of termination of job makers and the threat of job makes workers vulnerable. So you'll have a set of workers who would always be working under this threat that his job can be terminated at any given day if he raises any sort of a demand or if he objects to any practices of the employer. And the recent example which comes to my mind is Maruti struggle. Those who follow labor law and the labor struggles in India, the Maruti union struggle remains one of the most important struggle in labor history, in contemporary labor history. In 2013, a senior official died in Maruti Gurgaon plant, and there was a huge uproar. And even today, about hundreds of workers were put in jail. They were incarcerated for many years, and now 7 workers have been given life term. Their case is pending before the Chandigarh High Court, I believe. That after that incident, Maruti has another plant, one in Gurgaon, another one in Manesar. In Manesar, you will see that almost 90% of the employees are on a fixed term contract, that they will be hired, and after every expiry of 6-7 months, their contract will be renewed. Now, this has been done with the sole intention to curb the unionization of workers. Now, we see that the importance of collective bargaining and forming a trade union in a labor struggle is very important. It has been often celebrated and encouraged practice that in order to safeguard the interest of workers, trade unions are necessary. But these practices are like a total attack on it. So fixed term employment will legitimize hire and fire policy, will discourage trade union movements in India. So that is one of the threat, and that is one of the biggest problem with the new concept of fixed term contract employment in the new industrial relations code. Now, there are few concepts and few definitions which are vague. The new code retains the earlier definition of workman under section 2S of the ID Act. As I said earlier, that the workmen have been defined under section 2S of the Industrial Disputes Act. And in the new code, the terminology which has been used is worker, and the new section is 2Z subclause 2ZR of the where worker has been defined. Another section 2L defines employee. Now the definition of worker is same as it was of workman in the earlier act, whereas employee has been defined in a broader category. It is wider in its meaning and includes workers working in supervisory capacity, fixed term contract, like the one which I discussed right now. However, there is no clarity that what separate benefits will be available for employee and workers. So there is some sort of a vagueness in the definition part. Now, this is one another aspect. Now, one of the most important and which most of the unions and scholars have written about is the decision or the new provision in the new act which talks about that how closure, layoff, and retrenchment, as the concepts which I described earlier, that these new concepts, that how these termination of employees is being made easier. Now, one example is hire and fire policy by fixed term employment. The another is that Industrial Disputes Act earlier, in its earlier format, which is Industrial Disputes Act, provided that every industry which employs more than 100 workmen will have to obtain prior permission of the government before laying off, retrenching, or closing down the industry. So in cases where suppose for an example, industry A has 300 workers. So in case if they want to terminate the employees and close down the industry, they'll have to obtain prior permission from the government. Any industry employing more than 100 workers. Now what this code does, this code raises the threshold from 100 to 300. Now, how many industries in India employ workers more than 300? Not much. You'll see maximum industries employ less than 300 workmen. So what will happen? That in all the cases where industries are employing less than 300 workers, they can fire workers whenever they want to, and they do not have to get the approval of the government. In chapter 10, section 77 of the code, the threshold have been increased from 100 to 300. So this is one of the major change which has potential to shake the industry and to further put workers in a very, very vulnerable situation. Now, another aspect which requires attention is the introduction of administrative member in industrial tribunal. Now, as I mentioned earlier, what is industrial tribunal? It is like a court, like you see trial court, you can say loosely, that industrial tribunals are meant specifically to adjudicate the industrial disputes. And I was explaining earlier that what is the stages, that when a worker is terminated or when any dispute regarding worker, employer, employee arises, they file a complaint, then it goes to the conciliation officer. Once conciliation fails, there's a reference, and the reference goes to the labor court or industrial tribunal. Labor court and industrial tribunal are by and large the same thing, only the some issues lies before the industrial tribunal and some issues are dealt by labor code. It is mostly presided by a higher judicial officer, which is sessions judge, additional district and sessions judge. You will often see industrial tribunals are presided by them. Now, what is a change in the new code? What the new code does under section 44 subclause 2, that industrial tribunal will now be comprising of one judicial member and one administrative member. Now, what is the problem? Now, many people say that, what is the problem? Earlier it was a judicial officer, now there'll be a judicial officer and an administrative member. To understand this, that what is the problem, you may read a Supreme Court judgment, which is Roger Matthews judgment. Now, Roger Matthews judgment is on a tribunalization culture in India, where Justice Gogoi passed a detailed judgment and it was held that tribunals, and it consists and it deals with actually tribunals, different tribunals. It applies to tribunals like NGT, tax tribunals, DRT, debt recovery tribunals, educational tribunals. It will apply to all the tribunals. And what Supreme Court says, which is important here, is that in tribunals, the appointment is of a judicial nature because they have judicial power. And they should only appoint members from non-judicial background only if any technical expertise or specific knowledge is required. For example, if you see in NCDRC, National Consumer Dispute Redressal Commission, that there are often doctors. Doctors are on the board. You'll have one judicial officer and there'll be one doctor. Now, what does doctor do? Then cases of medical negligence, that where suppose you have a consumer case where somebody files a case that, while conducting a surgery, someone left a scissor, which is often heard in most of the cases, or some wrong medicine was given and something happened. Now, a judicial member will not be in a position to ascertain that what was the medical standard, what was the practice one a doctor should have used, and whether there is any fault. So for this reason, it was held that a person with a specific knowledge where any expertise is required, a person can be appointed in a tribunal. Now, in a industrial tribunal, the provision is that any retired civil servant for secretary level shall be appointed as an administrative member. Now, those who practice in labor law and go to labor departments and industrial tribunals would realize that it is a cesspool of corruption these offices have become. And now, if we have an administrative member who do not have any expertise in the field of labor laws, and they will be performing a judicial function, because administrative tribunals are meant to adjudicate industrial disputes. That is a judicial function. So that is something which is a problematic stand of the government, which they have. I think there's a power cut, but we'll anyways continue, it will come. Am I audible, Neil?
Yes, so you're still audible. Your screen is just a little dark. If you want, you could switch your screen off and continue speaking. And you can restart your screen if once the electricity returns, or you can continue speaking just the way you are. Depends on what you're comfortable with.
Yeah, I hope it comes back quickly. So that is one of the problem, and that is one of the objection that which trade union members and people who are working in the field of labor rights are protesting against. That if you bring in people from a non-labor law field, and if you bring administrative member in industrial tribunals, that is going to weaken the justice delivery mechanism. Now, another aspect which requires attention is power to exempt certain establishments. Now, this is important for the reason that Section 96 of the code provides power to the government to exempt certain establishments from the applicability of the code. That in case Supreme Court, any government thinks, state government or central government, that there is some reason to exempt certain establishment, they can exempt that establishments from the applicability of the code. So no industrial relations code shall apply on that, and the processes and the provisions of this code shall not apply. To understand it better, you will have to see the recent example where during COVID, many state governments exempted establishments from Section 5, taking help of Section 5 of the Factories Act, exempted establishments from following the norm of working hours of 8 hours. Now, Factories Act provides that every employee shall be working for 8 hours. Now, many states, almost 11, citing Section 5 of the Factories Act, which provides that in cases of public emergency, working hours norms could be relaxed. Now, citing COVID, many state governments raised from 8 to 12 hours. State of Gujarat went a step ahead and said that we will increase from 8 to 12 and we will not pay overtime. To understand this, it is important to refer to Section 59 of the Factories Act. What it provides, that every worker who would be performing their duty more than 8 hours in a day shall get overtime. So what is overtime? So usually when you're working from 1 to 8 hours, and when you're working beyond 8 hours, so from beyond 8 hours, for every hour, you'll get double the rate of your employment. So this provision was curtailed by the state of Gujarat. And this case went to the Supreme Court, where Justice Chandrachud in Gujarat Mazdoor Sabha case held that Section 5 notification, which state of Gujarat has made, is patently illegal and it was set aside. And in that judgment, in detail, Supreme Court held that first of all, two aspects. First of all, that it did not qualify as public emergency. COVID-19 cannot be held as a situation of public emergency, and for that, rights of workers cannot be curtailed. Secondly, referring to dietary principles of state policy and the duty of the state to safeguard the interests of workers, Supreme Court said that this notification has to go. So imagine a situation where any government, like more recently during COVID also, state of Uttar Pradesh decided to exempt state from all the labor laws except few. Minimum Wages Act and Payment of Wages Act, 2-3 acts were retained. So an act, state government would decide one day that industrial code will not be applied in our state for this reason. Now, by the time this reason is decided by the court, that will not be applicable. So these are the main highlights of the changes brought by Industrial Relations Code. Now, other act, as I mentioned in the beginning itself, that there are 3 acts which are being, clubbed together in this code. The other act is, first was Industrial Dispute Act, second is Trade Unions Act. Now, how much time do I have exactly, Neil? Can you please tell me?
So you can go on for 15 more minutes. It's all right.
15 more minutes. Okay.
Yeah.
I try to be a little brief because I think I took more time in the Industrial Disputes Act, but it was necessary as it is a main act. The second is Trade Union Act. Now, the Trade Unions Act, as the name itself suggests, is primarily meant for the registration of trade unions. Now, what does this new code does? That it changes the requirement of registration of trade union. In the earlier act, that is Trade Union Act of 1926, Section 4 provided that any 7 or more person could register a trade union. But now, under Section 6 of the code, the criteria of 10% of 100 workers has been introduced for registration. So you see that there's a bar is higher now. But it does not stop here. It makes further changes in the process of registration of trade union. And you'll see that it is it is an established principle, and it is a cherished concept of collective bargaining, that how important it is for industrial peace, that right of workers to form associations so that they can do collective bargaining is also what International Labour Organizations recommends, that every industry should recognize these rights. But with these new codes, these rights are being attacked. The other example of other change by this code is that earlier that any honorary member were allowed to be executive member. Now, what is honorary member? That suppose there is a garment factory and there are 100 workers in that garment factory and they want to form a trade union. Now, in many cases in garment factory, maybe not all workers are, literate or educated in that sense. So they invite maybe their well-wisher or another person, suppose a doctor, to be a part of their trade union. That doctor earlier under the provisions of Trade Unions Act 1926 could be a office bearer, general secretary, president. But now the new code prohibits that. Section 7E of the code prohibits honorary members from becoming office bearer of the trade union. Now the office bearer has to be from that particular establishment. And the deadliest is now the concept of sole negotiating union. This is a totally new concept which has been introduced in the new code and which has potential to totally discourage and discontinue or to break trade unions in different establishments. Section 14.3 provides that the union, section 14.3 of the code provides that union with at least 51% of membership of workers will be the sole negotiating union. What is sole negotiating union? That one union which the employer shall recognize that this is the union with which will engage and talk. So often trade unions will be negotiating with employers and maybe they will have settlement that you will revise our wages every 1 year. You'll provide safety gear. You'll provide clean drinking water. You'll make our workspace safe. Now, all this is done through trade union as a group. So now the concept of sole negotiating union and the threshold is that if you have 51% membership of the workers, then only it is a sole negotiating union. Now, it is often the case that in one establishment, there are many unions. Often you'll also see management sponsored union, that a factory owner will have their own union so that they masquerading as a leader of the workers, they'll come and they'll sign a settlement which has provisions which is against the workers or which does not achieve the goal of the workers' interest. So this concept of sole negotiating union will give unbridled power to the employers to weaken trade unions. By refusing to recognize or enter into settlement with the registered trade unions, employer will have disproportionate power in their hand to control the service conditions of the workers. And the other provision which this new code brings in is of concept of negotiating council, that is under section 14.4, which provides that no union has 51% membership and negotiating council shall be formed, which would have representatives from unions that have at least 20% membership of workers. So the smaller unions in one industry, so they'll form a negotiating council that all the unions will be part of that council. So this is another concept. Now, in terms of strike and lockout, that lockouts and strikes are another tool by which workers would often bargain with employers that they would conduct a strike. Now, this code makes it mandatory to give prior notice of 14 days before striking. Now, under section 22 of the earlier Industrial Disputes Act, such notice was necessary only for essential services such as railways and airlines. Now this extends to all establishments, making it nearly impossible to strike. Suppose you send a notice 14 days in advance that we're going to strike. Employer will create different ways that your strike is going to fail. What is the purpose of strike? The purpose of strike is to halt production, is to halt factory and bargain. That is the power which workers use. And also the definition of strike has been broadened to include concerted casual leave on a given day by 50% or more workers employed in an industry. So suppose workers en masse decide that today we'll take leave, will not go to the factory because we are not happy. And they would ask bargain from the employers. So that is also now discouraged by broadening the definition of strike, that even if you take leave by suppose 50% or more workers have taken leave, then that will be a definition of a strike. And there are provisions for penal sanctions for the mere fact of organizing and participating in a peaceful strike. And the third is, which is in Industrial Employment Model Standing Orders Act. That is a third, and this will be my last point, that how the threshold from 100 to 300. Now, earlier Industrial Standing Orders Act would be applicable to all the establishments employing 100 workers. Now this threshold has been increased, and it has been increased to 300 workers. So you'll often see that the direction into is that more and more industries are being exempted from the applicability of the labor laws. So we often see that more and more industries will not be required to follow the provisions or to implement the labor law statutes. So that is the direction in which today we stand. Movements are being weakened. Provisions are being made to weaken the permanency system. Workers are going to be working with a constant threat of termination of job. And contractualization is another aspect, which in itself is a huge topic. And we all know that how through contractualization workers are exploited. So this will give encouragement to such practices where workers will be more vulnerable and their exploitation is bound to increase. Thank you very much for listening to me. Now, I would like to have, if there are any questions, I would answer those questions.
Yes, sir. I have some questions, but they are not very legal as such. It's more of a practical based question, like a layman's doubt, that these trade unions, they form for the purpose of collective bargaining, right? Now, say in the digital age, what is the difference if in the face of all these obstacles, instead of registering a trade union, you just form a WhatsApp group with all of your workers, and you try to fulfill the same purposes, that you all speak with each other, you unionize in that manner. What is the essential difference? What difference does that create for the same objective?
See, one of the important aspect is that the purpose of a trade union is to enter into settlements with the companies.
Hmm.
And there is a provision in the act itself which says that what is a settlement and how the terms of the settlement shall be binding upon the employer as well as on the employees. So suppose employees enter into a settlement where they say that, yes, we will be working, for so many days in the company. And beyond that, if we work, we'll be getting paid something extra. Or in every year, we'll get some sort of extra leave. This is the settlement. Now, once this settlement is finalized, once an employer agrees to it, and if or they violate the terms of the settlement, workers can go to the court and say that you have to enforce this settlement because there is a binding settlement. Now, in terms of suppose you make a WhatsApp group, now there is no formal recognition of that WhatsApp group. The labor department has to ascertain the terms of settlement. They have to approve it. So once it is not approved, it will not be a binding thing in the court. So that is a problem. Otherwise, definitely as a strategy, you can form a union, go slow, and bargain with your employer. So that is one aspect, and that is what is important in terms of settlements.
Okay, so that really clarifies the importance of having a trade union that is recognized and official, and that the employers do negotiate with rather than having a front with a management sponsored trade union. Yes, that helps a lot. Another similar practical question I would have to ask is that in these past 3 days, we've been speaking about if your rights are violated, like once we graduate as students and we become workmen or employees. If our rights are violated, we have to go to the court. And you spoke about how in the court things can take 5-10 years multiple times. Today, you've mentioned that there is a process before that in your redressal for grievances where you go to a conciliation officer first, right? So this is a topic we are bringing up the first time today. So here, I'd just like to ask you to elaborate a little more on what this position is, because I wouldn't believe that a lot of us are aware what a conciliation officer is in the first place, where we can find them, how to approach them.
So when Industrial Disputes Act was brought in, the idea is, and still today, even you will see Supreme Court judgments where they have often reiterated this concept, that industrial tribunals are not bound by the strict technicalities of a dispute resolution system. They can, in order to achieve justice, can pass orders. So it is a more of a relaxed norm. And when Industrial Disputes Act was, legislated in the aftershock of World War II and the initial years of India's independence, it was believed that poor workers should not get entangled into this whole chakkar of courts, and there should be a more of a formal but of a more relaxed conciliation proceedings and all that, where they could uh, have conciliation where disputes can be resolved quickly rather than having a very adjudication of every dispute, where leading evidence and final judgments are being passed. So this was the idea behind conciliation. Now, what is the reality today? The reality today is that in most of the cases, conciliation is just a time consuming process. A worker, I will come to the processes involved in the conciliation, but I'm highlighting the challenges. And it is not only because all the labor inspectors are corrupt and all that. It is also for many reasons, like the judiciary, that your labor departments are understaffed. You do not have staffs in labor departments, so your whole labor law administration is so fragmented and weak that it is not possible, and it is further being gradually being deteriorated. You do not have appointment staffs and all that. So that takes a longer period, and the conciliation, which the process was meant to go to a system where employees and employers can sit down and settle the disputes quickly, has become an added extra time in the whole process of dispute resolution mechanism. Now, a conciliation process is usually done by labor officers. They can be either labor inspectors, labor commissioners, deputy labor commissioners. In different state governments, different authorities are assigned this duty. Like in Gurgaon, they will have labor inspectors as conciliation officer. You also have assistant labor commissioners as conciliation officers. So that is where you have to go and file a complaint. They would forward that complaint to the management. They would call management. You negotiate with them. You do enter into conciliation process. If it is settled, you go back to your duty, or you take your money back and relinquish all your claims. If it fails, then with that failure report, you go to the labor court, where the whole process of industrial dispute shall be adjudicated by a judicial process.
Right. And can an individual who has faced a violation go and approach this officer, or do you need to go through a labor union, trade union?
Now, this aspect has been relaxed by an amendment in the Industrial Disputes Act in Section 2A. Earlier, only a trade union could represent workmen, and they could file dispute, and that has to be adjudicated. Now, the Industrial Disputes Act, through amendment, provides that every individual workman, if their services have been terminated, then that would be considered as industrial disputes, and they can raise industrial dispute. And I would further add that in order to avoid this delay in the process, it further makes an amendment where it says that if conciliation, what usually used to happen earlier, that you have conciliation fails, then you have to wait that it will go to the government will make a reference to the labor court. And that would often take 4 months, 3 months, 5 months. In Gurgaon, it would often take 8 months. That today conciliation has failed. Now the worker is waiting that my reference will come to the labor court, then I'll go. So in order to address this problem, an amendment was made that once the conciliation fails, from that day, after the expiry of 45 days, you go directly to the labor court. With the failure report, you take that failure report, take your claim, go and file it before the labor court after expiry of 45 days. So now individual workmen can also raise industrial disputes. That is Section 2A of the Industrial Dispute.
And all of this still continues under the new Industrial Relations Code?
Yes, that continues under, I don't remember exactly which provision, but that continues in the new industrial code as well, that the individual workman can file industrial disputes.
Okay, hopefully that is really useful information for all of our students here who are soon going to become graduates. And it is just a minute till 5 o'clock now, so we can come to a close. So would you have any closing statements? All the questions have been completed and asked.
With only one line I can say that, now since most of you are from Mumbai had a history of labor struggle, and 80s, 90s saw a growth of many labor trade unionist labor law practitioners, which eventually has come to a lull today. There's some sort of decline in labor law practitioner, and I don't know why, because it is not fashionable or what. But I must say this, that labor law practice is most sustainable practice. in terms of technicalities of law, in terms of the differences which you make in the society, and in terms of money also, if I must say this. That workers will come, they will pay your fees, and you can sustain your practice. So it is one of the most lucrative field in the field of law. If you are thinking of practicing, then this is one of that field of law where you can actually think of your career.
So on that note, then I'd also like to ask that you mentioned that a lot of these government seats are sitting empty, where these inspectors or these commissioners are supposed to be here to help through the process. So how do you get into those positions? Like as a student, if they want to fill in these positions and help with the labor disputes, would you know?
You have appointments being made of assistant labor commissioners. These notifications come here and there, so you'll have to keep an eye. These are government jobs. You have to keep an eye on that whenever the vacancy is announced, central government has its own vacancy. Like industrial tribunal, they will have central government industrial tribunal, CGIT, which is like 2024 in the whole country. Half of them are vacant. For example, there is a central government industrial tribunal in Dhanbad in Jharkhand, and that presiding officer takes charge of Kanpur, which is like almost 1,000 kilometers away. So that is the fractured labor law regime in India today. But yes, I hope this will be filled by young law graduates who are willing to go and take up this responsibility.
Hopefully that inspires some of you to go towards this goal. And on that note, we can conclude today's session and go towards the vote of thanks, for which I'd like to invite our programming officer of NSS GLC, Kritika ma'am. Ma'am, you may take this spotlight.
Okay, am I audible?
Yes, ma'am, you're clear.
Okay. Good evening, everyone. Now we are at the valedictory address of the 4 days lecture series on new labor codes organized by the National Service Scheme of Government Law College, Mumbai, in collaboration with HRLN, that is Human Rights Law Network. I would begin with thanking our learned speakers for enlightening us with the insights of all 4 new labor codes, namely Wage Code, Social Security Code, Occupational Safety and Working Conditions Code, and lastly, Industrial Relations Code. Since last 4 days, from 28th of January 2021 till today, we are being apprised about the new changes in labor code affecting our rights, benefits, and obligations as employees as well as employers. So I thank Advocate Aditi Saxena, Professor Rahul Sapkar, Advocate Shubham Kaushal, and today's learned speaker, Advocate Mr. Gunjan Singh. The information you imparted with us, sir, will definitely help us in all our current as well as upcoming jobs, placements, employments, occupation, profession, whatsoever it would be. Thank you very much, sir. Now I would like to thank Mr. Niranjan Deshpande, sir, of HRLN, that is Human Rights Law Network, and everyone working with HRLN for collaborating with us to organize this wonderful and excellent 4 days lecture series. We are definitely looking forward to organize more and more such wonderful sessions with you. Thank you very much, sir. I would like to thank Dr. Puranik, sir, Director NSSL, Mumbai University, who appreciated our notion of spreading legal awareness through NSS and happily agreed and granted us permission to conduct the university level activity. Thank you very much, sir. I would like to thank our principal, Dr. Rohidas Kaya, sir, for his constant guidance and support, and who has nothing but all praises for each and every activity of NSS. I'll also thank all my senior colleagues for their encouragement and admirations we receive always from them. I would love to thank all the NSS volunteers participating from all over NSS units under Mumbai University and other viewers for their marvelous and enthusiastic participation in thousands of numbers. If you see the number of viewers until yesterday's lectures, it really feels brilliant. Finally, but most importantly now, I must thank the core members and volunteers of my GLC NSS unit. Actually, you don't thank your own family members, but if each and every appreciation will encourage them to do more and more, I would praise them every day. You guys are doing excellent, and thank you for being here with me. Thank you so much. I once again thank everyone. Thank you for being with us in this 4 days lecture series on new labor codes. Always looking forward towards your participation in all our future events. Thank you very much.
Thank you, ma'am.
Thank you very much.
Yes, thank you, sir. And thank you, ma'am. With that, our webinar series of these 4 university activities comes to a close. The feedback link for your attendance has been posted in the YouTube description. You can fill that now. And yeah, thank you for being with us. Goodbye.